persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at while within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to the Appeals Court. I am Justice William Mead. With me today are Justices Wolohojian and Walsh, who will be the panel for all three cases. Four cases, excuse me. One just got added. If you've been here before, you know each side gets 15 minutes. You needn't use all of your time. We don't entertain any rebuttal. We've read everything, so it's my best advice that you get right to the point. With that, I'll call our first case, 22P209, Commonwealth versus Pierre. Mr. Benzaken.
Thank you, Your Honor. Good morning. Jason Benzaken for Mr. Pierre. In a case where we have a black man charged with killing a white man, the trial court committed reversible error by failing to seek a race-neutral reason for the Commonwealth's striking of the only black person on the venari. And I intend to focus my time before you at this oral argument, focusing on argument one, this section of my brief, and I intend to submit the remainder of my arguments on the brief. The trial judge committed a reversible error in denying Mr. Pierre's Batson source objection to the Commonwealth's use of a peremptory strike on juror number 74, the only black person on the venari, stating no pattern. Pierre had satisfied his prima facie burden of establishing a discriminatory purpose to the Commonwealth striking of juror number 74 because he was a black man charged with murdering a white man, and she was the only black person on the venari.
Well, she wasn't the only one.
Well, thank you for bringing that up, Your Honor. I believe she was in this case because I think what determines what constitutes the venari depends on the procedure employed in each case. And in this case, the procedure that the trial judge employed was, when the trial court we often refer to as a panel method. What the judge did was posed questions to the entire jury pool when they first came in.
Yeah, that's normally what's known as the venire, I think. Everyone who's called up to the courtroom at that time.
Correct. Now, but his method for striking, again, different judges call it different things in the courtroom, but his method for sitting...
Let me ask you before you get into arguing what the meaning of venire is. I didn't see anything in the record that would reflect what the racial composition was of the venire on day one. Can you point me to something in the record that would show me that?
I can point to the statement made by Brian Kelly at the time he made his objection. At the time he made...
So apparently there were 3 people of color in the venire.
Well, what he indicated was that 2 people had been excused as deemed not qualified.
Right, so they had been in the venire.
Well, I think, you know, the SJC addressed...
You can't be excused from jury service unless you were in the venire. I mean, just as a matter of logic.
Correct.
Okay.
But I guess when I refer to the venire that counts for the purpose of the Batson source analysis, I'm looking at Commonwealth versus Benoit. And there the SJC looked at a jury selection process that was similar to here. The selection process here is instrumental in understanding what counted as...
So if we were to accept this premise, then the analysis would be different if the judge had required peremptory challenges to be exercised to each juror one by one, or to each venire person one by one, so that then the venire would be one person? Is that what you're arguing? Because that would be, I think, the logical consequence of what you're saying.
The venire, well, the judge has to base his decision based on the totality of the information available to him or her at the time the objection is made. So certainly the way the jury selection process plays out in each case is going to change the analysis relative to that factor.
But it wouldn't change how many people were persons of color in the venire. That seems to me to be a matter of fact.
In Commonwealth versus Benoit, on this is exactly what had happened. The judge had set up a process whereby jurors were individually questioned. Those who were deemed qualified were seated in the jury box. Those deemed not qualified to serve were excused. Once the judge had fully filled the jury box with qualified jurors, That is the point where peremptory strikes were made. And in Benoit, the court made clear that at that time, in that case as well, there had been other black jurors who had been excused. But for the purpose of the Batson analysis, what counted was the qualified venire that had been reduced. And at the time the objection was made in Benoit, the court was not considering the jurors who had not been considered qualified because they don't fall into.
So what we have here then, if we say that, is we're just looking at the people whom the judge had deemed indifferent and put into the jury box.
Correct, Your Honor.
All right. So if we accept that, which would mean, in my view, that you're not raising a challenge to the process by which the venire as a whole was constituted, by which I mean everyone who was called up to that courtroom.
No, I'm not.
Right? You're not making any challenge to that.
No, this followed the procedure that's required.
Okay. So then it seems to me what we need to know is, what your argument is that the judge needed to inquire of the Commonwealth, pose an explicit question to the Commonwealth as to why they were challenging juror number 74, even though the Commonwealth had just said why they were challenging juror number 74. So do you have a case that says that the judge needs to ask, even when, if the prosecutor says, here are the 3 reasons why I'm challenging the person, then the defendant says, I'm raising a Suarez objection, the judge needs to ask again, even though it was 2 sentences earlier?
Well, I think, again, this depends on the case.
Okay, but I'm looking for a case.
Well,
do you have a case that has similar facts?
Well, I think in here, what it the reason he was not able, the peremptory challenge.
I hate to be repetitious, but when I ask for a case, I'm usually looking for something that says like Commonwealth versus something.
Well, then I would suggest that Commonwealth versus Sanchez answers this, where Judge Gaziano makes clear that the analysis for determining whether or not a defendant has met his prima facie burden is made at the moment the objection is made.
All right, so in that case, did the Commonwealth state its reasons before the defendant made an objection?
The Commonwealth made statements not for a peremptory cause. They made their grounds of an objection what they sought for cause objection, which is at the point the judge was determining qualified jurors. The judge rejected.
And the judge then said she can exercise a peremptory challenge.
And it would have been legal error, and it would be legal error if he had made a ruling on a Batson objection at that time because it was not before him. The objection had not been raised at that time, and the totality of relevant
He found no pattern.
Well, if I may, as to that, I would suggest that's erroneous because our case law has indicated a pattern can be established by one juror.
But it doesn't have to be.
Well, I would submit that, like as in Benoit, we have the same situation that we had in Benoit, where in this case, at the time the objection was made, the qualified juror venire that had remained, there was one black juror in that qualified venire. So
No, there's another one. It's juror number 34 is African American.
that was the next day. And for the purposes of the analysis, we're not supposed to look at the next day. We do not know what happens the next day. The venire is based on the existing venire before the court at that time.
Can I just interrupt and jump in for a moment? Because we spent some time clarifying that you're not challenging those who were deemed unqualified. But when there's only one person of color in the whole veneer or venire, however you choose to pronounce it, how do you prove a pattern?
Well, I mean, you have to look at the totality of relevant circumstances at that time.
Right. So what's your argument that it's not anyone's fault that there's only one person of color in the whole veneer, right?
Because
But Batson Soares wants to make sure that those jurors who are sitting and hearing the evidence aren't challenged because of any discriminatory reason, right?
exactly.
So one of the ways is to show a pattern, but where is the abuse of discretion? Where is it that the judge got it wrong? I'm looking at, there's just one. So what should have happened that didn't here that you say is reversible error?
Well, I think what should have happened here is exactly what happened in Prunty, which is where the SJC stated that at the time when standing before the judge at that time, we have one black juror in a venire, and we have an interracial killing case, that it is, unlawful to, I mean, a prima facie burden is established simply by raising a Batson objection as to that juror. So I think that is the analysis we have here.
Okay, but it's not required, right? It doesn't mean that just because there's one black juror, that that person, even if a legitimate reason, even if there's a legitimate reason to exercise a peremptory, must be seated, right? That can't be, is that what you're arguing
No,
for?
I'm not saying they're seated.
Okay, so I think that's what Judge Walsh is trying to get at. So if we accept that premise, that a black juror can be challenged properly, right, by the Commonwealth, what is it that's wrong here with the challenge that was exercised to juror number 74?
Well, I guess I am disputing I'm disputing that it is okay for the Commonwealth to challenge. I'm suggesting that as soon as that objection is made, the defendant, and again, it's not just because it's the only black juror on the Venari. It's a conflation of factors that Prunty has indicated. It's a conflation of the factors of an interracial killing. It is a juror of the same class as the defendant, and it is the only juror of that racial class in the Venari.
Okay, so you're saying, is your argument that, are you arguing for a per se rule that in those set of circumstances, the black juror cannot be removed from the juror?
No.
Okay, so that's what we're trying to get at here, right? So if there's no per se rule, what is it here that prevented, because the Commonwealth articulated several reasons, which are genuine reasons. The juror had provided the information herself in response to voir dire questioning. So why is it that juror could not then be peremptorily struck?
Because procedurally under the Batson-Soares analysis, the defendant had met his stage 1 objection and raised a prima facie burden. Under Benoit and Maldonado and the whole progeny of those cases, the requirement of a judge is once that objection is made, must then turn to the Commonwealth and inquire of the Commonwealth as to a race-neutral which is required to give a genuine and adequate race-neutral reason for striking the juror.
That's only if they find a pattern.
And I'm suggesting that the prima facie burden, pattern is tied.
You want to change the rule. It's the next argument in your brief, right?
Well, no, I'm suggesting that pattern is one of the ways of proving a prima facie burden. I'm suggesting that on Prunty under Harris, they've also indicated that our pattern language has been satisfied and that pattern requirement has been satisfied in the past.
We're evaluating the judge's decision that there was no pattern for an abuse of discretion. And how does his decision fall outside the range of reasonable alternatives? Since the Commonwealth had just given 2 race-neutral reasons why they wanted to strike the juror.
But because the defendant had met his burden, the judge was required to inquire specifically at that time.
You're starting with the conclusion that he met his burden.
I'm sorry.
I asked how the judge abused his discretion in determining no pattern occurred. And given that the Commonwealth had just given 2 race-neutral reasons, how does the judge's decision that there's no pattern fall outside the range of reasonable alternatives?
Because that was incorrect as a matter of law, because under Harris and Prunty, the fact that was the only qualified black juror and this was an interracial killing, that alone satisfied his pattern, his prima facie case.
Those cases say it's automatically a pattern.
Prunty does. Prunty says the defendant meets his prima facie burden. Pattern is one of the ways you meet your prima facie burden on the first stage objection. The standard has always been, and it is.
Prunty involved only a single black juror?
Yes.
And it says that a single black juror can constitute alone a pattern?
Harris sets that forth, and Harris was the first case that set that. That was affirmed then by the SJC and Fryer.
Let's assume it's a prima facie case.
Yes.
It can be rebutted.
Correct.
And here there were reasons that the Commonwealth gave. So why isn't that the end of the story?
Well, there's 2 reasons. First, at the time the Commonwealth gave its reasoning, not all of the information that is relevant for the analysis was before the court. This peremptory strike was not made at the time. They objected for cause. The judge overruled it, sat that juror, and they continued to go through over 10 other jurors, interviewing them, continuing to seat jurors in the jury box, qualifying some, not qualifying others. We don't know if some of those unqualified jurors that were black came afterwards. So the proper information for the court to evaluate this had not been before it at the time that the Commonwealth had raised its for-cause objections.
Were there other jurors seated without objection whose son had just been prosecuted by the DA's office the week before?
Not identically. However, we had two other jurors who had three other jurors who had various forms of criminal justice system involvement, who had been seated at that time, who had not been subject to the same kind of questioning by the Commonwealth, and were not subject to strikes. So there were other individuals who had personal or familial experience with the criminal justice system. One of the jurors, in fact, had an extremely negative experience, so much so that she indicated she sued the police. And none of those jurors were subject to the kind of inquiry that juror number 74 was, nor were those jurors
Were they
subject to
seated?
strikes. I'm sorry?
Were they seated?
Yes. Yes. And ultimately, even though we may suspect that what the judge's reasoning was, once the defendant met his prima facie burden, the judge was required to make findings of fact as to an adequate and race-neutral reason, and he had to make specific findings as to both of those factors.
All right. Thank you.
Thank you.
Ms. Mello.
Oh, I did have a question on the argument you didn't want to make.
Sorry.
I'll ask you.
Good morning. If it may please the court, Elizabeth Mello Marvel for the Commonwealth. It is the Commonwealth's position that the judge did not abuse his discretion in this matter, even if the panel decides that there was a prima facie showing of a pattern, which the judge did not find that in this matter. But even if the panel found that there was, as has been pointed out already, the Commonwealth had provided race-neutral, appropriate, adequate, genuine reasons for the challenge. In looking at cases that have been reversed, such as Carter and Jones, that was because race-neutral reasons were not on the record. And here, those reasons very clearly are on the record. So it's Commonwealth's position that that is different.
Did you find, to answer one of Judge Wolahogian's early questions to your brother, did you find a case that spoke of the sequence of the reasoning and whether they had to be repeated having just been stated?
I did not, Your Honor. I cannot speak to that. I did, as I mentioned, the cases that talked about whether or not they were on the record, but not specifically about the sequence. So I apologize, I do not have.
Well, if there isn't one, it's hard to find.
Thank you. I do not have one. In regards to the other jurors, I would like to address that since that was just spoken about. The 4 challenges that the Commonwealth made, of those 4, juror number 74 was the only juror on that first day who indicated that she herself had a substance abuse issue. The other jurors did not mention that. And she was the only juror to, as Your Honor had pointed out, have a family member, her son, prosecuted just the week before by the same DA's office, quite frankly, in the very same courtroom. That's very different than the other jurors who were ultimately seated, who talked about having a brother who had a drug case 25 years earlier, one who they had their own drug case. However, that was in New Hampshire and had nothing to do with the same DA's office. And the individual, the juror who sued the police department, that was in 2003, so several years earlier, and had nothing to do with the DA's office as well. So it's the Commonwealth's position that, yes, those individuals did have some interaction with the legal system, but it did not rise to the same level as the juror that was challenged because it wasn't so close in time, it wasn't involving the same DA's office, and so for those reasons, they were not similarly situated, and that they were seated appropriately, and juror 74 was challenged appropriately. If the panel has no further questions, the Commonwealth would rest on its brief in regards to the other issues that were raised by my brother.
I do have a question about the argument that there was an erroneous felony murder instruction. What I'm trying to figure out is if we were to agree with the defendant, what would be the consequences to these convictions? And the reason why I'm asking that is because count one, which was originally charged as murder in the first degree, the verdict slip, there's only one conviction on that count, although the jury identified two separate theories for that conviction, as I read the verdict slip. And then the docket reflects just a single conviction. Afterwards, a single conviction on count one. Then there were the other convictions as well on the other three counts. Those other three convictions were subsequently dismissed because of the felony murder rule, as it looks like on my docket, that they couldn't stand because there had been a felony murder conviction. What happens if, you know what I'm trying to figure out, what happens if the defendant's theory is correct, or the defendant's argument is correct with respect to both the conviction on count one, which rested on two separate theories, and the other convictions?
I'm sorry, Your Honor, I'm not sure. I think I got lost in the question. I'm not sure what exactly it is that you're asking me.
Well, what I'm trying to understand is whether, if a conviction rests on two separate theories, murder convictions rests on two separate theories, and we know here that it does because of the way the verdict form was set up. What difference does it make if one of those theories might need to be vacated because it was, let's just call it for the sake of argument, the product of an erroneous instruction on the law? Just assume we were to say, yes, the instruction was mistaken and it had some effect or required. So what difference would it make? Can you help me understand mechanically if it would make a difference?
I don't know that it would, only because when there's more than one theory, the Commonwealth is not required to identify which theory.
But here
So-
there was, well, I know, but here, well, at least we know the jury identified two theories, so I was wondering whether, even if one needed to go by the wayside, the conviction stands?
If the evidence was sufficient to support what was needed in that theory, the answer, I would presume, would be yes.
Okay, so me too. So then that led me to my second question, which is, if the theory that gets kicked out, here felony murder, was the basis for dismissing the other three convictions, what, if any, effect is there on the dismissed convictions?
On the dismissed convictions?
Right, if those convictions were dismissed because of the felony murder rule.
I don't believe there would be any.
None, okay, they'd
Effect.
still remain dismissed.
Correct.
They wouldn't be reinstated for resentencing.
I don't believe so, because they wouldn't, I don't think they would be able to be.
Well,
If it's a theory that you can't go forward on.
They
were
were
they
just-
dismissed after conviction?
Yes, they were dismissed after conviction based on the fact that, I think, if I
Merger.
read the docket, yeah, right.
It's merger, yeah.
If the panel chief agrees, I'd love to get a letter from both of you on what.
Yeah, that's
what-
fine, yeah.
Yeah, what the consequence would be there.
Within 1 week.
Only on that topic.
Okay. Okay. If there are no further questions, I would rest on my brief.
Thank you. Thank you
Thank
both.
you.
Our next case is 22P317 Commonwealth versus Abernathy. Mr. St. Lawrence.
Good morning. May it please the court. My name is Tim St. Lawrence. I represent the defendant Franklin Abernathy. This is his appeal from the denial of a motion for required findings of not guilty as to so much of the judgments that adjudicated him a habitual criminal. The motion was denied on the grounds of direct estoppel, and this court will review that because it's a question of law of whether direct estoppel applied in this case de novo. We submit that the judge did err in applying the doctrine of a direct estoppel for several reasons. In this case, the Commonwealth would have had the burden to establish the prerequisites for direct estoppel, and we think they failed on each and every one. If they fail on any one of those, direct estoppel does not apply. So number one is that the issue must have been litigated before, and it has to be fully litigated. The way this came about is a little unusual. Mr. Abernathy in 2017 had filed a motion to correct an illegal sentence based on the fact that he had 3 habitual criminal adjudications in this case. There had been an SJC case that came out that said multiple enhancements are unlawful, so he based his motion on that, appealed the denial of that motion.
Can I interrupt for a moment?
Sure.
So we have Abernathy 2014, we have Frank Abernathy 2017, 2018, now we have Mr. Abernathy again in 2023. But in 2017, you're claiming it's just pure dicta when 3 members of the appeals court says, here the evidence established that at the time of his 3 felony convictions in 2008, the defendant had previously been convicted 4 times and had on each offense been committed to state prison for a term of 3 years or more. The defendant does not claim otherwise. And so while I understand that his argument was focused on consecutive or concurrent sentences, when you go back to docket 17P 904, the Commonwealth briefed it. They knew that sufficiency of the evidence may very well be a live issue. I would say over 50% of their brief was dedicated to showing why there was sufficient evidence on the habitual offender. And so then the court puts this in there. I mean, if it was for no other reason, I wouldn't think that the authors would put that in there other than to say, hey, if we're thinking of an illegal sentence, don't we have to make sure that the sufficiency of those claimed illegal sentences is there?
The court definitely did that. They again, as you correctly stated, this was raised for the first time on appeal by the Commonwealth in the appellee's brief. So Mr. Abernathy never litigated this issue.
He could have. He could have filed a reply.
Perhaps.
So
However,
in other words,
as the appellant,
the law doesn't require, well, I'll pick here, and then 5 years later, I'll go back and I'll pick one more slice of this argument, right? I mean, even if it's not direct estoppel, it's not whether Mr. Abernathy chose to litigate that matter. It's, was it there? Was it argued? Did it have a right? Did it have a chance to be appealed, which in this case it did, because further appellate review was denied by the SJC. And so tell me why this opinion here doesn't foreclose getting to the merits. And I know you want to argue the merits too, but tell me why it doesn't. I mean, he could have raised it. The Commonwealth put it out there. The appeals court mentions it, and the appellant says nothing.
right, so, and I understand, you know, a pro se party is looked upon as if he has a lawyer, so, but that you know, the issue here for him is, well, let me back up, okay, because I think there's a couple things
I mean,
that you're
even if it's
getting at.
not a stopped, you know, can't we just cite to our former opinion
To say it's a
and agree?
stopped.
And just say there's sufficient evidence? Wasn't one of the ideas behind estoppel or res judicata or issuing claim preclusion is judicial economy?
Yes, absolutely. Here, let me talk about maybe another problem with this, okay? So, he did not have an opportunity for review of
Sure he did.
the appeal,
Sure he did.
not as of right.
Well, does direct estoppel require as of right?
Absolutely.
It says opportunity.
Opportunity
So he
to
could
appeal.
file, he could
You
file.
have a
I'm
right
talking-
for
We can't talk
automatic
at the same
appeal.
time. You have to stop talking. He had an opportunity to apply for direct appellate, further appellate review.
That gets granted in 2% of cases.
And he did apply.
It's still an
further.
opportunity.
Right, and
But
he did apply.
it's an opportunity that you have an automatic right to appeal. You have an opportunity to take it. Even if you don't take it, direct estoppel applies.
So is your
But you
argument,
have to have an opportunity as of right. Here's the problem with the appeals
as of right.
court
It does not say as of right.
deciding,
Again, you can't talk at the same time the judges are talking. It doesn't work. Where can you tell me it requires an as-of-right opportunity?
for the doctrine to make sense, it has to require an
Do
as of
you have a
right.
case that says
I
that?
do not have a case.
Okay, thank you.
so let me just back up for one moment, because is what your argument is that the sufficiency of the habitual offender argument was not essential to the claim of the illegal sentence?
That's right, it was not essential. It was a preface in getting to the real issue in the motion, in the case. It was dicta, it did not decide the issue. There's no analysis whatsoever. There's no argument from the other party who now is losing a right, apparently. So this is not how direct estoppel works.
All right, let me ask you though, because I think I'm a little bit confused at this point. Your client had a right to pursue a direct appeal from his convictions, correct?
Yes.
And he also had and that includes the right to pursue a direct appeal from the sentencing enhancement, the habitual criminal conviction, correct?
Yes.
And that portion of it. And so he has that right. He exercised that right here, correct? To
Yes.
take a direct appeal.
He had a direct appeal.
But he did not raise any challenge to the sufficiency of the evidence on the habitual criminal portion. So why isn't that where estoppel kicked in?
That would be an argument for waiver. Our argument to that would be you can't waive an insufficiency claim where that always creates a substantial risk of a miscarriage of justice.
Okay, so you would say that doesn't stop him. It merely means that the argument was waived. And so then when the Commonwealth briefs it, the argument of the sufficiency, and he has an absolute right to file a reply brief under the appellate rules. Doesn't need leave of court or anything. He can file a reply brief, but he chooses not to. At that point, why isn't there estoppel? When he knows that the argument's been raised by the other side?
So I guess that theory would say that he had a chance to fully litigate it, so.
And he knew it was on the table,
under
and then
your-
so how is that?
So perhaps they've crossed that bar of he's actually litigated the issue.
Yeah,
However, when you get to have they determined it, you have a sentence in a judicial opinion with no analysis
But they determined
whatsoever.
it based on what was before them. That happens all the time.
Okay.
So the Commonwealth put forward the evidence that it has, probably the same evidence here, the previous docket sheets, blah, blah, blah. And they note correctly in the previous decision that the defendant doesn't contend otherwise, doesn't challenge the sufficiency on that. What's
That
wrong?
again would be waiver, but
that's the determination to which he was entitled, based on how the case was presented the first time around.
I disagree with, an appellee raising a new issue in their brief and then.
That's what a reply is for, right? To address issues
Not new
raised
issues
in a.
that weren't raised in the
was
motion in the
raised-
trial court below. But even if, take that and concede the first two, so now we're to number 3, and that's, was it essential to the decision in the case?
That's number 2.
Okay, well, I did litigated, determined, and then
The litigated determined is 1,
essential
2 is
to the,
essential, and 3, the opportunity to obtain review.
okay.
So if we go to the merits, let's talk because we have 4 minutes left. Can you tell
Right.
me why this was insufficient? You've got 2 live witnesses, right? You've got the 2003 and the standard in the light most favorable to the Commonwealth. And you've got
A fingerprint expert.
fingerprint expert, you've got some
Right.
information about more than just Frank Abernathy, right?
So here's kind of where I think the courts have kind of been overwhelmed by that evidence that actually doesn't tie him to the 99 case. There was never any fingerprints from the 99 case that were compared to the 2007 case, which was the basis of his conviction. So those fingerprints meant nothing to prove the 1999 case. So what we're left with, and all the pen packs
But we
and
have, Mr. St. Lawrence, we have a photograph, we have the same physical characteristics, we have the same name, the same date of birth, the same parents' names.
we have none of that for the 1999 case. We have that for 2004, 88, 92, and the present case. But all they have for the 99 case is Exhibit 7. And Exhibit 7 is name only.
Name, I think it's date of birth for 6 and 7 in place of residence.
Well, 6 is the 2003 case, so that's not connected to the 99. They haven't connected that to the 1999 case. They need to connect Franklin Abernathy in the courtroom to the 1999 case, which is Exhibit 7. That's all they have. If you look at Exhibit 7, it's only his name. There's no identifying information.
Do we have certified dockets from 99?
We have what the Commonwealth entered in evidence was a certified docket of the 1999 case and indictments.
And, I mean, when we look at this, right, we're looking at a judge who's making a finding beyond a reasonable doubt. And in the prosecutor's closing, is very aware of the issue of identity and says, Judge, look here. And then we have some missing pieces in documents, which frankly happens every once in a while, that pieces of paper get lost. But it seems to me that those first few pages, because now we only have 3, 4, 5, and 6, and not 1 and 2, but 1 and 2. And the prosecutor saying, Judge, look at these pages. You'll find all this information.
Yeah, and I think
How do
that,
you,
yeah, if I could address that, I think that's a little misleading because, and this is on Record Appendix 103, 104, where they get into this. And first of all, Mr. Abernathy is saying it's name only. So we kind of have two countervailing pieces of what's going on here. So then you have the prosecutor say, he's saying, you know, with a specific date of birth, I believe, I don't have the documents in front of me. So he thinks that he's given these documents up that have all this information on it, when in reality, he didn't. It was an oversight, apparently. He says, I don't have that conviction in front of me.
Was Mr. Abernathy in the courtroom?
He was meant to be here today.
Not this courtroom.
Oh, I'm sorry.
At trial.
Yes.
So the judge, who's the fact finder, can see him.
Yes, he represented himself at trial. However, there's no picture of the 1999 conviction. So how?
Do you have anything?
I have one question.
Okay, go ahead.
Do we know where Exhibit 7 starts and ends? I have start as RA 155, and what effort was made to ensure that that what we have here is the entire thing that was marked as an exhibit in the trial court?
Right. So it is beginning on RA 155. This, and as you can see,
Goes through Exhibit 7, goes through where?
goes through RA 163.
163.
Now, if you look at this, this is the court. This was what's in the court record.
It is? Okay.
It is.
All right,
The Commonwealth
that's my
confirmed
question.
that. I just wanted to make one other point, and I'll sit down.
I think
Okay.
you
No, your time
would
is
need
up.
leave.
Thank you.
Ms. Lyman.
Good morning, and may it please the court, Mackenzie Slyman on behalf of the Commonwealth, asking you to affirm the defendant's, affirm the denial of the defendant's 25B2 motion in this case. Turning first to the issue of direct estoppel, the motion judge did correctly deny the defendant's motion on the basis of direct estoppel. Here, the Commonwealth did prove that all 3 of the requirements for direct estoppel to apply were in fact met, that the issue was actually litigated and determined, that the determination was essential to the defendant's conviction, and that the defendant had an opportunity to obtain the review of that determination. I believe the court has touched on basically the Commonwealth's entire argument here.
Was it essential, though? I mean, you can take a look on Westlaw, and you can find cases in which illegal sentences, let's just say, you know, the judge sentenced somebody to 5 to 10 and the maximum sentence is a 4 or something like that. I mean, why was the sufficiency of the habitual offender essential to the issue before the court in Abernathy Part 3?
Sure. I certainly would say that the issue is essential to that panel. As the court has pointed out, the Commonwealth very thoroughly briefed this issue. In its appeal, the defendant had the opportunity to file a reply, had an opportunity to move to strike that portion of the Commonwealth's argument, and he failed to do either of those things. And the Commonwealth as well put in its appendix all 7 exhibits that were in front of the trial judge at the habitual offender trial. So the appeals court had all of the information. A spotlight essentially was shined on the issue by the Commonwealth, and the fact that the appeals court made such an explicit mention and ruling and determination on the sufficiency of the evidence indicates that it was essential to them to first make that conclusion before going on to the legality of the sentencing scheme. And I would urge this court as well to review the exhibits that were put in that are in the record in this case, that were in the record of appeal on the 2017 docket. If the court looks at the all the evidence that was presented there are only 4 possible convictions that would meet the qualifications here, the 1988, the 1992, the 2003 conviction, and the 1999 conviction. Those are the only 4 convictions maintained in those exhibits where you do have the required also triggering sentence of 3 to 3 in a day.
There's no fingerprint card from the 99 case?
No, it was not admitted as an exhibit.
And you're saying, so the other overlapping information in the other convictions is what ties it together?
Yes, that's one of my arguments, certainly, is that looking at all of the evidence that was put in connects back to the 1999 docket and that conviction, but specifically in terms of what the previous panel had access to, looking at the exhibits, of those 4, you have the nature of the conviction and the sentence that was attached to them. So by virtue of the appeals court saying that the defendant had previously been convicted 4 times, it's clear that they thoroughly reviewed the exhibits, reviewed the record to reach that conclusion.
But as your brother indicates, how do you tie it to the 1999? So sure, you might have nailed it on the 1988, 92, 2004, but you have to prove the 1999, right? Because the indictment was 2003, and there's no quarrel. 2003 is
Correct.
good. So just because he's the same Frank Abernathy in 88, 92, right? Where is it that the overlap shows that he's Frank Abernathy in 99?
Sure. Well, I have 2 responses to that, Your Honor. First is, as the Commonwealth addresses in its brief, that we are missing pages of the certified conviction here.
I don't know, because, I mean, you say that, but if it is true that what's in the record appendix from pages 155 through 163 is what was introduced as Exhibit 7, then the exhibit itself may not have included those 2 pages. And the fact that they're missing doesn't help you, because the exhibit is what was the evidence at trial.
Yes, Your Honor.
So, I mean, I know you refer to, well, there were these 2 missing pages and there might have been something on them, but unless those 2 missing pages were introduced as exhibits, how does that help you?
I think we can infer from the record here that they were introduced as exhibits.
I don't know. We can infer what was or what wasn't. We have here Exhibit 7. The Commonwealth has not. What have you done to establish that what is marked as Exhibit 7 and included in this record appendix is not accurate in terms of what was Exhibit 7 below? Because Exhibit 7 appears to have been a packet of things, not just purely the docket.
Of course,
So
yes.
how are we supposed to decide that there were 2 pages missing from this exhibit?
Of course. So I will say that I did reach out to the appeals court directly myself to obtain their retained copy of Exhibit 7, and it does mirror that which is in the record today. So their copy is also missing those 2 pages. But I think also the copy is missing that final signature page with a certified conviction, and that we do have that with Exhibit 6, the 2004 docket. So I think the absence of that final piece that makes it a certified conviction, that shows that it was certified by the clerk's office, also supports the inference that there are some missing pages. However, that did happen from the Exhibit 7 that was put into the record at the trial, and what exists and is maintained by the clerk's office at this point. And
The clerk's office in the trial court?
Yes, the clerk's office in the trial court. I
They
reached out
have
to
no
them.
record of what was Exhibit 7 at this point?
They have the same Exhibit 7 and the same pages that are contained in this record.
It seems to me if there's a missing part of a record, trial court record, there's a process for reconstruction.
That's true, Your Honor. Neither of the parties here have taken the steps to reconstruct the record. I think recognizing the amount of time that's passed, it's difficult. And I would point out to the court, too, if you look at Exhibit 6, there are 2 versions of the 2004 docket in there, and you can see that they're formatted differently. So even, and again, recognize that we did not take that step leading up to the appeal here, but even recognizing that the formatting essentially changes of the clerk's printout of the docket, it's frankly unlikely that we would have even been able to, even if we attempted to reconstruct the record today, reconstruct it in a manner that would give us the exact 2 pages that we're missing from.
So it seems very difficult, at least for me, to imagine that we're going to be able to just infer that there are pages missing, infer that those pages were included in the original exhibit, even though the trial court's exhibit today does not include them, and infer what information was on those missing pages.
I appreciate that, Your Honor.
Okay, so assume that we can't make all of those inferences, which is what would be necessary, I think, in order to accept the notion that there was more information tying the defendant other than his name to the 1999 conviction. Can we go back to Judge Walsh's question, which is, how do you then prove that the 1999 conviction is for the same person?
Certainly. So I would argue that the trial judge adequately made that determination by looking at the entire volume of evidence that was put in before the court. I would distinguish this case from Commonwealth versus Coney that I know the defendant relies on in his brief. And that's a situation where to prove all of the necessary predicates, there was only a packet of evidence put in. Here we have far more evidence that was put before the court. We have 2 live witnesses, we have 3 fingerprint cards, a report from the Boston Police Latent Print Unit as to those fingerprint cards. We have the defendant's booking sheet where he offered his own personal information. So I think that the connection there, where all of that is the same, is a Franklin Abernathy, that the trial judge, in the instance where she didn't have those 2 dockets, though the Commonwealth again maintains that the record would support that those were in front of her at that time, that for her to connect the 1999 docket to all of the other evidence that was presented to the court was reasonable at the time, and still under the light, looking at the evidence in light most favorable to the Commonwealth, would support maintaining that conviction on all 3 of those habitual offender counts. And I think just as a last note, in terms of, actually, you know what? I will rest on my brief if the Commonwealth has no further, if the court has no further questions.
Just one question. Is Assistant District Attorney Tilley still employed by your office?
I'm sorry?
Assistant District Attorney employed by your office?
She is not, no. She's no longer with the appeals unit and no longer with the District Attorney's office.
Thank you.
Thank you very much.
Thank you. The next case is 22P461, Commonwealth versus O'Neill. Mr. Gaffney.
Morning, Your Honors. My name is Edward Gaffney, and I represent the defendant, James O'Neill, with me.
Hold the microphone closer to you, Mr. Gaffney.
Sure. Are you able to hear me now?
Yes.
Okay. My name is Edward Gaffney, and I represent the defendant, James O'Neill. With me is co-counsel Elizabeth Hugetts from the CPCS Innocence Program. At the outset, I'd like to focus on the 3 areas in the trial that I believe were badly flawed as a result of evidentiary errors made. The first, and probably the most significant, is the series of hearsay rulings that prevented the defendant from presenting to the jury his version of what happened at the show-up identification at his house. The Commonwealth's version was pretty straightforward. The victims, DR and RW, and Detective Ridlon all testified to the fact that all of the police that brought them and the victims all went into the kitchen at the same time. And the defendant was there, and the victims identified him as the perpetrator.
I thought the victims identified him when he was coming down the stairs. Was that inside the house?
Yes, this was all in the kitchen. Now, there was a little bit of discrepancy in details like, was he on the bottom of the stairs that led from the second floor into the kitchen? But at the heart of it, I focused on the actual identification process itself. As the Commonwealth put it in, it was everybody in the room at the same time with the defendant who was in the room, and the victims just said he was the guy. And at trial, RW and DR both testified there was no doubt in their mind. But when the defendant tried to put on his case, he called his mother first, and she testified, or she was prepared to testify, that it wasn't everybody all at once. R.W. came in first, and Detective Ridlon asked him a question repeatedly, and she was prepared to testify that finally R.W. said, "No, I don't think so, that's not him." And he was taken out, and D.R. was brought in by another officer, and the officer said, "Is that him?" And D.R. said, "No, that's not him," and then he was taken out. And the defendant then was prepared to testify that the police took the victims to a different part of the house, talked to them for a few minutes, and then they all...
Maybe, Mr. Gaffney, it would have been much different if counsel had made that offer of proof that you're telling us now.
Absolutely, Your Honor. There was a combination of failures at the trial. I think that the evidentiary ruling was extreme with respect to the hearsay rule, and the defendant's attorney really fell down on the job. I mean, as far as putting an offer of proof in there, Mrs. O'Neill was probably she did the best job that she could. She was interrupted more than once, but she tried.
There were motions for new trial, right?
This is a motion for new trial.
No, there were prior ones.
Oh, there was one, yes. There was a direct...
But the mother didn't file an affidavit for 28 years.
Correct. And the motion judge, in a footnote in his ruling, said that the delay, puts these affidavits in a negative light with respect to credibility. But he also says that this is a deeply troubling case because of these statements made by the witnesses, which he also called deeply troubling.
Well, he also said that he wasn't sure what the statements actually were, because this Ahern report, not an affidavit like you say in your brief, not an affidavit, he even testifies it's not an affidavit, is all over the place. It's an amalgam of statements that he himself, based on his memory, put together, and he has Alzheimer's disease.
Exactly, Your Honor. And yet, with all of that acknowledged, the motion judge again said that the case and the statements in 2006 were deeply troubling. And even taking to Mr. Ahern's evidentiary hearing testimony, I summarized it here, but basically he kept coming back to the fact that both DR and RW were not certain that O'Neill was the guy, and went along with...
That was part of what they said. They were equivocal, they didn't want to participate, they were drug-addled, they were homeless, they didn't sign affidavits. There's no attribution in the report of actual things they definitely said, because he declined to make that representation, Ahern did at his testimony. Who knows what they said?
Well, we don't know precisely what they said, but the heart of what they said was, I wasn't sure. And the reason that that's important is because that's what was the Commonwealth, that was the whole case for the Commonwealth. They were...
Let me ask you this. I don't think the judge spent much time on this, but in general, when you file a motion for new trial that calls into question or impeaches the evidence in the Commonwealth's case, it is not grounds for a new trial. How is this case different?
Because this was not just an evidentiary error, precluding the defendant from putting on the impeachment evidence that he had, was not just an evidentiary error. That was a constitutional violation. Basically, the defendant's...
if Drayton applies, right?
No, I'm not talking about the Drayton piece. I'm talking about the fact that there was nothing more to this case for the Commonwealth other than the identification. In other words, there was no physical evidence, there was no forensic evidence.
Well, I mean, frankly, I'm having a little bit of trouble with the analytical framework of your arguments, so perhaps you could help me with that. As I understand it, you have certain claims that fall under what I think of as the category of trial errors. So the exclusion of certain evidence from the mother and from the defendant, and the missing witness instruction, right?
Right.
Those seem to me, if I understand your argument correctly, because we're not here on a direct appeal, so we can't look at those as though we're on a direct appeal. We're here in the context of a motion for new trial, and I take it the theory is that for the motion for new trial is ineffective assistance of counsel. Is it appellate counsel?
Both.
Okay, trial counsel and appellate counsel. So you need to establish both that, you need to establish both prongs of Safarian, right? And you need, and we review that for what?
Well, this case is a substantial risk of a miscarriage of justice
Okay,
case,
so
no
that's
question
where we would
about
have
that.
to be for that. Okay, and then the second argument you're making is newly discovered evidence?
Right.
All right, and it's newly discovered in what sense? The witnesses, right, the victims were known, they testified at trial. And so, and it doesn't look like, I think that's where I see this factor of delay as really being a component, right? It's what efforts did the defend, I think the judge was saying, well, first of all, let's just step back for a moment. What is the standard of review for the denial of a motion for new trial based on newly discovered evidence?
Well, motions for new trial, it's always abuse of discretion. Right.
All right. So why couldn't the judge, in exercising his discretion on the motion, consider the delay?
Well, he can, he did.
Yes, he did, and he can. So if he did so, did he abuse, are you arguing that he abused his discretion in considering that?
Well, my argument is that my weakest argument here is that the judge abused his discretion with respect to the newly discovered evidence piece. Okay, there's two issues here.
But it seems to me that you're in an abuse of discretion. You're in the realm of abuse of discretion for all of your arguments.
That's right, Your Honor, and I believe that the evidentiary rulings are the failures.
Evidentiary rulings are not directly before the court. What's directly before the court is an ineffective assistance of counsel claim. That's why your argument sometimes, as you phrased it, sometimes puzzles me.
Okay, well, let me, if I may, I'll address that, Your Honor. I start with the evidentiary rulings because they are the crux, or they are the foundation for the failures of the attorneys.
To raise them on appeal.
As Justice Meade pointed out, to start with, to provide an offer of proof, to object appropriately, and then to the failure of the appeals attorneys to raise this, either in a motion for new trial or even on direct appeal. I mean, there's some stuff that's right on the record that just got missed. And so when I start with the evidentiary errors, I understand that the court's not going to be analyzing this appeal on a direct appeal basis. I'm starting by explaining the foundational nature, the deeply, the strong evidence here that was left out. I mean, from my position.
I don't know if it was that strong, to be frank, because unless I'm misunderstanding the trial evidence, the children make a report after they get themselves out of the laundromat, they go to neighbors who call the police. We have a firm chronology of time on that.
Right.
They call the police respond, they see the defendant leaving the Sunnyhurst convenience store at 1:30 in the morning. That's the evidence from the police officer.
One police officer.
No, the second police officer. And the second police officer then observes the defendant walk to his house. The defendant is wearing clothes that match the description that the children gave, according to that same officer.
I disagree, Your Honor. There was no evidence that, and no one testified the defendant was wearing jeans and sneakers. He was wearing dark pants and desert boots.
I thought there were two police officers, not just Ripcon or whatever his name was, but the other one. Do you remember his name?
Donahue, I think?
Maybe. Didn't he testify that, I thought I saw that in the record, as to the person that what the clothing was that the person he observed walked from Sunnyhurst to the defendant's house?
Right. Dark pants, if I remember right. Dark pants.
The child victims gave detailed descriptions of the suspect.
Right, Your Honor.
And
Clothing, size, build, hair color, chipped tooth.
Right.
And the officer that sees the defendant says he matches those.
Right, but he didn't. I mean, he had a missing tooth, and the chipped tooth was supposed to be in the front of his mouth, and the missing tooth was on the side. I mean, there was definitely reason. Oh boy, I'm running way low on time here. Let me just quickly make sure that I emphasize to the court that this was not a strong case. Okay, the defendant was tried a year earlier, and there was a hung jury because of the strength of his alibi. He testified, and 7 alibi witnesses in a child rape case, 7 alibi witnesses testified to corroborate his whereabouts, including a total stranger, a woman who served him and his 2 friends, who also testified, at a Dunkin' Donuts at midnight when in Charlestown, the perpetrator was taking these victims into the laundromat the laundry room where he later attacked them. And he had 2 other witnesses testify that he was in Kenmore Square with the 2 people that testified with him, O'Neill's the defendant, Henry Coates and Eddie Reed. Jerry Supre and Jackie Sindoris met them, or they were in Kenmore Square at 1.
All we can conclude from all of that is the jury didn't believe any of them.
Well, remember that this was weakened unfairly by evidentiary rulings, which again were not objected to appropriately.
It was argued thoroughly in closing, right?
It was argued by the prosecutor that these alibi witnesses lied, and that there were recent contrivances, none of which he was able to come back on, again, because of the evidentiary rulings. The Commonwealth also got away with arguing, without any rejoinder from the defendant, that there was the clear-cut and definite identification in the house. And again, the defendant was entitled, I mean, my read of this is either the defendant gets to put in the evidence that of what his version of this show-up was, or there's not a fair trial.
All right. Thank you, Mr. Gaffney.
Thank you, Your Honors.
Ms. Jordan.
Good morning. May it please the court. Darcy Jordan on behalf of the Commonwealth. The judge.
Do you think this is newly discovered evidence?
No, absolutely not. I think Judge Wolholgen pointed to the fact that these victims were known the whole time. I think it's troubling that there was such a delay. I think Judge Ricciuti points out that this might not be the case if these were sought out. I suggest to you in 1990, an investigator had found RW. We have in 2006, the investigator finds both. And in 2006, it's frankly abandoned until my brother is involved in the case. So to say that somehow this hodgepodge of Ahern's recitation in this report somehow is newly discoverable, I think not only runs the face newly discoverable case law, but I think the best case scenario for my brother is that if it falls under Drayton, and frankly, Drayton is an outlier in and of itself, that frankly says it should be rarely used, that newly discovered evidence that is...
It has to be reliable
And it has to be reliable. And I think my brother tries to fit it into the 3 requirements in Drayton, but I think he ultimately fails because it all comes down to what is reliable. And Drayton, although well, first of all, in Drayton, the evidence was an affidavit, and the court found that it was like a dying declaration because that victim who came forward herself, and I think that's a meaningful difference here because we have victims here, and I should also say that the affidavit in Drayton was written 18 months after the conviction. So if we only compare those few points, I think the defendant's claim fails in and of itself right there because we have 28 years later, we have the histrionics of these victims. And I think the fact that they're not coming forward, is meaningful because we don't even know what Ahern is asking them. We don't know if we have resident victims that are looking to put this behind them. I think what we do know is that these were troubled men, that it seems like this event haunted them throughout. So based on those alone, this already falls outside the rubric of Drayton. But then we have, to compound it, we have Ahern's Alzheimer's disease. And I think if you read through his transcript, I think it's very apparent how he struggles to have an independent memory of his conversations with these victims. And again, the hearing was in, I think, 2021, and he met with these victims in 2006. So anybody, even if they don't have Alzheimer's, might have some failings of memory, but here it's just ultimately compounded. And the fact that Ahern, I think meaningful, never says that the victim said, I lied on the stand. The victims never say, the defendant didn't do it. And I think when faced with this kind of evidence after the fact, I think the judge got it right here, that it does not scream of the credibility of the Drayton affidavit. And moreover, in Drayton, there was corroborating evidence as well. And here, the only evidence corroborating the victim's statements are the victim's statements. So the corroborating evidence in itself fails because it suffers from the same calamities, right? So if the defendant's argument is RW's statement in 2006 is corroborated by DR's statement in 2006. So I think that in and of itself fails. I don't know if the court has any other questions about the newly discovered claim. If I could just move on to the mother's statements. I think my brother goes too far in how he assesses this evidence, because of the transcript itself, there's one question posed, and it's to the mother, and it's, the detective asks RW something numerous times, and then there's objections sustained. Now, even if that was error, that it could have been admitted for a non-hearsay purpose, that's not offered in the record. Basically, the defense attorney abandons the line of questioning at the mother, and I think what my brother is doing now is now in 2021 was when the mother wrote the affidavit, is now saying, well, I would have done this, I could have done this. And when we're looking at ineffective assistance of counsel and a motion for in this juncture of a new trial, that's not right. That's not the appropriate question before Judge Raschuti, nor the proper question that you guys are to review upon that. My point in the brief in looking at the mother's testimony is saying, even if we consider that mother's testimony, it doesn't really help at all, because the testimony at trial does support that DR says, I don't know. And I do point to some transcription sites to basically say that this jury heard evidence that that at least DR was offered that he was not sure. And Detective Ridlin also testifies that DR said, I wasn't sure.
But doesn't mother say that they were not certain, or they did not make an identification until after Ridlin spoke to them?
Yes, she does testify that, and that's day 2 of the trial transcript at 4:04. So I think that actually helps my argument, because it does.
So that wasn't excluded?
That was not excluded. So the jury did hear that from the mother that the victims and the detectives had some independent conversation during the show up. And again, that's day 2, page 404. And I just want to also point to your honors that the testimony where DR is saying, I initially didn't know, I wasn't sure. That's explained by him and Detective Ridlin saying that I think RW was in front of him is one characterization of that situation, and the other was DR says, well, when they asked me who it was, the defendant's father was there, and I was confused, so then I moved. So if I could just point to those transcripts, RW is on, actually, RW on cross, it's day 1, page 136, and I should clarify that the question posed to him by defense counsel was, did you hear what DR said? And he responds, he said, I'm not sure. It was objected to and it was sustained. So I think my point is only that it was explored, not necessarily the evidentiary ruling specifically. And the part when DR testifies that he initially said, I don't know who it was, is on day 2, page 178. And Ridland's testimony, who talks about how DR said, I'm not sure, that's day 2, page 311. So I suggest to you, even if there were errors made about that, the defendant wasn't precluded in some way of offering testimony about the ID. And frankly, the defense attorney didn't really explore it with other witnesses. He had ample opportunity to cross both victims and Ridland and explore it with the defendant, and frankly, he didn't. And I think what really screams for there is that if we have an ineffective assistance of counsel claim, there was no such affidavit in the first motion for a new trial. It wasn't raised any below. And I know for that the defense counsel has now is deceased. And again, this is where this case is wanting for the delay is really attributable to the missteps taken by the defendant. And just one other point is that it seems like the defense attorney's real focus was the alibi in this case. So again, without having an affidavit to show any strategy that was perhaps utilized, it very well could have been the strategy not to attack before a jury, 11-year-old and 12, or now they might have been 15 and 14 at the time, and instead focus on this alibi. And the alibi was quite fulsome. He put on 5 friends, his girlfriend, his mother, his father, and the woman, the waitress from Dunkin' Donuts. So this is not a case, as my brother says, there was not a fulsome defense. It seems to me, and based in the closing, that all the eggs were kind of in the alibi basket. I don't know if your honors have any questions about that, the evidentiary points. The other, no. I think the other point I'd like to raise is any questions about the missing witness instruction. I think at the end of the day, either the jury bought the alibi witnesses and didn't. And even if the missing witness instruction was an error, and I do go through more specifically, some of the witnesses and what they could have contributed, I think at the end of the day, it really wouldn't have made a difference in here. Either the instruction would have had the jury buy the alibi a little more or a little less, but at the end of the day, it's clear that the jury disregarded all alibi evidence and credited the victims here.
Is there a transcript from the first trial?
I do not have the transcript from the first trial, Your Honor.
I'm wondering because the defendant, makes much about the fact that the outcome from the first trial and the second trial were different, but if there's no transcript, I just don't know where that, how to assess that argument.
And I'm sorry, if I can have one more point about the standard of review. I think, Judge Rollholgen, you were talking about the standard of review, and I think it's abuse of discretion, but I did want to point out that when analyzing the ineffective assistance claims, it's really, the defendant has to overcome waiver, essentially, under those claims, so substantial risk of miscarriage of justice before Justice Raschuti, because none of those things, arguments were raised in the either appeal or the first motion for a trial, which was after the appeal. Seeing no other questions, rest my brief. Thank you.
The appellant's lawyer is not here.
Do they have any word from him?
They tried to reach him, but just goes to voicemail.
He's probably on his way. Should we take a break and then see what happens
let's do
for
that.
15 minutes? And do
We'll take a short break. Thank you, Shanette.
All right, rise, please. Court is in recess.
Good morning. Our next case is 22P644, Zeller versus Zeller. Mr. Clark.
Good morning. My name is Robert Clark. I represent the appellant, Richard Zeller. If it pleases the court, this is an interesting matter, and I think in some respects it's a novel question, beginning first with a question of the sufficiency of the court's findings on a complaint for contempt, and then second, with respect to the court's remedy, having found Mr. Zeller in contempt. Now, stepping back, this matter all evolved from a slightly disproportionate divorce judgment, which had left Mr. Zeller without the liquid financial assets to pay off his ex-wife pursuant to that judgment. He had requested, having been given the former marital home, which the court had valued at $500,000 in its findings associated with the judgment. He had been left with that property, and in order to fund the eventual resolution of the case and to pay off his former spouse, he had requested leave to sell the property. He was unsuccessful in doing that. It eventually proceeded to an initial contempt complaint, and a judgment entered on May 25th of 2021, whereby Mr. Zeller was required to enter into a
He was ordered to list the house for sale by a date certain, which he did not do.
by a date certain, which he clearly had not done.
Right, okay. So, and the May 25th, 2021 contempt judgment was not appealed, correct?
That judgment was not appealed, no. This
Not
is
appealed,
the
right.
subsequent judgment entered in March of
Right.
22.
So, so what we've got is an appeal from a subsequent contempt judgment,
Correct.
and given the failure to list the house by the date required, where's the problem?
I guess the problem becomes, well, obviously in the course, in a finding of contempt, we have a three-part test. First, whether the underlying order is clear and unequivocal, whether
Well, you don't argue that that portion is not clear and unequivocal.
not with respect to the June 25.
Right, so it doesn't
listing date.
matter. He doesn't need to be in contempt of all the provisions of the judgment. He can be in contempt of just one.
Correct, and then there's the question of the week delay in getting the listing agreement signed, which goes to really a question of the willfulness of the disobedience, and I think more fundamentally whether it really had any effect on his ability to comply with the underlying request.
Were there other incidents prior to this where the husband failed to cooperate?
Yes, there were several. And I came into this matter very late after the trial, and actually after a request for additional time to enter proposed findings and a proposed judgment in the initial divorce trial. And Mr. Zeller is disabled, and he does have an unusual personality. And it can be very difficult to work with and very difficult to communicate with at times. However, following the entry of the listing agreement just after July 4th in 2021, the marketing went forward as expected, and the question for the evidentiary hearing eventually became what exactly were the instructions of the agent which Mr. Zeller was required to follow. Our position.
But the judge made findings, right? The judge found that the realtor I'm just going to call him the husband because I can never remember names, sorry. That the husband insisted on a listing price that was higher than what was recommended by the agent based on market factors, that he refused to heed recommendations from the agent to lower the price, that he did not agreed to lower the price until a week before the listing expired. There was the judge made plenty of findings to show that, to support a finding that he was not cooperating with he was not doing what he needed to do to really sell the property.
That may be true. However, that does not, seems to step over the question of the contempt itself. And in this instance, it goes to the question of whether there was a clear and unequivocal order of the court.
Well, there was, that he had to list it by a certain day.
Correct.
So why, so I'd like to just go back to that. Why is that not the end of the story?
Well, honestly, I think to some extent it has to go to a question of degree. The argument has not been made that the delay caused any meaningfully impaired the sale of the home. And the sale of the home was problematic and in fact.
But, you know, it required, it doesn't matter, right? Because in the end, the wife has to pursue further proceedings in order to get what, you know, the house sold. It's basically get what was previously ordered to have happen.
Mm-hmm.
Why isn't that the prejudice? You're not supposed to have to keep litigating the recalcitrant person.
Correct. And here we have a question about whether, well, initially, the house was not required to be sold. Initially, the house was left with Mr. Zoller.
But then he said, I can't satisfy the divorce judgment without selling the house.
Correct.
Okay, so then he has to sell the house.
And then we get to the question, I guess if we could step back to the question of the remedy. I think the bigger issue, and this is where the novel question comes up, is the court's power under Rule 70. And as I've noted, the court certainly can appoint an agent pursuant to Rule 70 to carry out a discrete task, and ordinarily that's just going to be some sort of ministerial act. We have numerous bankruptcy cases in which an agent is appointed pursuant to Rule 70 to execute documents on behalf of a debtor. In the context of a divorce case, and this was Harrington, Rule 70 was used to actually affect the entry into a listing agreement with respect to property that was required to be sold.
The judge, the authority to directing a conveyance thereof may enter a judgment divesting the title of any party investing it in others. You can take a title of a property. This is far less than doing that, correct?
Well, this is not, essentially that is what happened here. And I think a distinction needs to be made because the underlying judgment did not call for the conveyance of the property. It called for Mr. Zoller to pay basically a money judgment. Lacking the financial resources to do that, he sought recourse in the property itself. And we would think ordinarily, and this is expressly noted in Rule 70 itself, that the court can issue an execution and thereby encumber the property pending whatever eventual sale or other disposition might happen with it. In this case, the court effectively conveyed the property to a third-party agent and said, do what you're going to do with it, and left really no accountability to the agent to act within any specific guidelines set by the court. Ordinarily, obviously, under Rule 53, we would expect an agent to report to the court. I noted that a similar procedure is required of a bankruptcy trustee, which I guess is more analogous in this case than anything else, because the agent was established to liquidate the property. Now what eventually happened.
But Rule 70 appears to me to be specifically directed at disobedience in the court. So there's a judgment, there's an order, and somebody is not complying. And so somebody doesn't have to be on the verge of bankruptcy. They could just say, not doing it. Take my own sweet time. I'll ask for $2 billion for this piece of property, the grist mill. If there's disobedience, then we can have a third party act as if they own it and take action as was required by the judgment. So why is that novel?
Well, really, what we're looking at here, this is a seizure. I mean, fundamentally. And there were no restrictions at all placed on the agent's authority. Now, going back to the case law, obviously, if the initial disobedience was the failure to enter into a listing agreement, obviously, and this is illustrated by Harrington, that the Rule 70 could be used to affect that entry into a listing agreement as ordered. And I don't think there really needed to be anything further than that. Considering further disobedience, assuming that, a monetary amount was determined as a proper remedy, that could have been attached to the property by way of execution. I think in this case it actually was, subject to whatever additional terms might be required of the court, including accumulation of interest and potentially attorney fees, pending an eventual sale. I think the question here is how, considering that the assessed value was substantially above any of the original listing prices, and the agent, the Rule 70 agent, had originally listed the property at about $500,000 and abruptly reduced the list to $400 in what appears to be a fire sale.
But there's no evidence that it was anything other than an arm's length transaction.
Not that I'm aware of.
Right. So, and I can't put my hands on it right now, but I believe that the Rule 70 order actually was quite detailed. Can you remind me of the page, the record appendix page of the Rule 70 order?
Offhand, Your Honor, I would have to.
It didn't just say go sell the property. It was fairly detailed, was it not? Can you recall what was in it?
It was fairly detailed.
Okay, so I'm not sure it's fair to just argue that it was like a complete abdication of or amorphous abdication of responsibility to the agent. I'd like to put my hands on it if you can give me the page number. Oh, maybe it was in the supplemental.
Page 77.
That's what I thought, of the appendix. That's the contempt judgment. I mean, that's the first one where it says if the judge, this is where the judge gives the husband fair warning that if he fails to comply with the first contempt judgment, that the judge will consider appointing a neutral third party in accordance with Rule 70. But then I think there was a subsequent appointment order, correct?
There was a subsequent appointment order. That is the order of March 14th. And this will have been G3, and I believe it is page 18.
Well, it's okay, we'll find it. I know it's in there. It was, I think, for our purposes here, we can just agree that it was a detailed order.
It is a detailed order, and actually that's page 86 of the record appendix. And the deficiency, as we see it, with respect to the order is that it retains no authority with the court to oversee the activities of the Rule 70 agent. And that seems to differ substantively from other situations in which a sale of a property can be ordered, whether by way of a master or a special commissioner in a petition for a partition or a bankruptcy trustee, all of which are answerable to the court and subject ultimately to the court's final approval of a particular determination made by that agent. I think in this instance, there would be a legitimate question as to the legitimacy of the offering price and the accepted price, and that is where, that is our greatest concern.
One more question.
Oh, good.
Sorry. So I just want you to assume for the moment everything, that we agree with you somehow, that we agree with you. What would be the relief here?
That's the question.
The money has gone, I'm wondering whether the whole thing isn't somewhat moot, because the wife's now been paid, the contempt judgments have been satisfied.
Mm-hmm.
So can you help me with that?
I think hypothetically, well, that is the tricky thing. How can this be undone?
Or what is there for us to do? It seems to me sort of academic.
Well, we certainly would seek that the order, that the judgment of contempt be vacated. What happens with respect to the eventual
Well, nothing.
disposition of the real property?
Because
Yeah,
it
obviously.
just satisfied his obligations under the divorce decree. That's all it did.
That is all it was intended to do.
All right.
Thank you.
Thank you.
Mr. Asaf. Did I get close?
Pardon me?
Did I get close to pronouncing your name correctly?
Asaf, yes.
Oh, good.
Good morning still. Michael Asaf for Jill Zeller, the appellee. I have an advantage over Mr. Clark in that I was trial counsel in the matrimonial action. Before you, you have what I refer to as nested contempts, a contempt of a contempt of a contempt. Remedies issued by the judge in an effort to give Mr. Zeller, who was pro se at the time, an opportunity to go forward and to do the right thing. You'll recall from my brief, perhaps, that there were 11 contempt applications filed during the trial itself. Each time, judge decisions bent over backwards to give Mr. Zeller an opportunity to come into compliance. Each time, Mr. Zeller failed to do that. That behavior continued into the post-judgment era, where he defended the application for contempt that he hadn't paid the money by the date certain by saying, I have to sell the house to be able to satisfy the judgment. What he did have at the time, contrary to what counsel says, and if the court looks at the judge's decisions, which are quite detailed, he did have cash to pay. He may not have been able to fully satisfy it, but he could have paid significant sums going forward. He chose not to, and instead defended the contempt application by saying, I have to sell this house. It's the only way I can do it. So the judge structured a process by which he was going to sell the house, and he was immediately in contempt. I'm not sure what counsel is driving at with respect to, well, it was only a week, it's really not that bad. We don't have a doctrine in this Commonwealth that I'm aware of where we talk about substantial compliance with judges' orders, particularly in the totality of these circumstances where you have an individual who has been in contempt at that point 13 times, which is kind of a record in a matrimonial action. Generally speaking, people serve time in jail. Mr. Zeller did during the trial. He served, I believe, if memory serves, Thanksgiving weekend in jail for one of the contempts before he purged it because he raised the money to purge it. He chose not to pay my client and to frustrate my client and to economically exhaust my client, who was the non-titled spouse. This marital estate consisted of well-defined money assets in accounts and 2 parcels of real estate. That's it. Everything was well-defined. Everything could have been whacked in half. It was a long-term marriage with 1 child. There was no need for any of this. My client spent several $100,000 on a divorce that should have cost no more than $15,000 tops. And all of it was exactly the result of Mr. Zeller's behavior, his failure to comply with judge's orders, his failure to do the right thing at every opportunity that he was given. He just didn't want to give her the money.
Okay, so I hear all that, but it's helpful, at least to me, if we can focus on just what's in front of us in the appeal.
Certainly.
I know you guys are all steeped in the whole history of the litigation down below. To me, perhaps, do you mind turning to the Rule 70 argument?
Certainly.
So essentially, what I understand the husband to be arguing is that, sure, Rule 70 permits the judge to appoint a third party to, in essence, carry out something that the party directly in front of the court is not doing.
Correct.
But I think what he's saying is that shouldn't happen without some kind of supervision by the court. And I don't know if this is explicit or just implicit from his brief, but he's saying, and that should have happened here because the property was sold for less than fair market value. That's in essence what I think he's trying to argue.
Except, Your Honor, and you'll note from the decisions by the court, there was no market analysis ever performed.
I know,
by Mr.
I
Zeller.
don't know if he's able to really establish in this record that it was sold below market value, but set that aside. Let's just take the piece of his argument that says that the court just can't turn the entire action over to the real estate agent without, at a minimum, requiring some report back to the court.
The Rule 70 order requires Counsel O'Sullivan to report to Mr. Zeller every time there is or there was someone who is interested in seeing the house that may wanted to buy it.
It's not really a report, right?
Well,
that was more like she'll tell you when someone wants to come see it.
Well, there's more to it, Judge.
I'm looking at it right now.
Yep. He was also supposed to report, or she was also supposed to report any offer. Mr. Zeller was never prevented from, at any time.
I didn't see that. Can you show me where that is? The language?
I don't have it with me, Your Honor, because I didn't know.
Okay, so I have the Rule 70 order here.
Okay.
And it says, appointed to sell the real estate. She shall have sole authority to enter into a listing agreement with a realtor of her choosing, continue to utilize the realtor currently under contract, establish a listing price, and modify same based on market conditions and the recommendations of the listing realtor, negotiate a purchase price, execute all documents necessary to complete the sale, negotiate with lien holders, and take any other action reasonably necessary to complete the sale, including making reasonable repairs and completion of a Title V inspection. Then all costs associated with that attorney's work shall be the responsibility of the defendant and shall be paid from the proceeds of the sale of the property. If the proceeds are not sufficient to compensate the attorney, the defendant shall pay the difference within 30 days of the closing. I don't see any obligation to report.
Mr. Zeller was living in the home at the beginning
Okay,
of
but
Counsel
report
O'Sullivan.
to the court. You
Understood.
said that she was obligated to report any offers to the court, but I didn't see that in there.
Forgive me, I thought that was in there, but I
Okay.
will say this. Mr. Zeller was not prevented at any time from doing a market analysis, coming to court, filing a motion with the court saying, regardless of the fact that this individual was appointed to sell my home, this is the market analysis at which the price should be set. And he never did that. He never performed any market analysis. And so as the process went along, and Mr. Zeller was very litigious all the way through this, so it wasn't as if he was afraid of coming to court and challenging any position that I took or any position that the judge took. In fact, he challenged all of them. But he never did anything with respect to the process and the sale of the house. Mr. Clark was representing him at the time, so he wasn't pro se. So as a practical matter, if they felt that his due process rights, which is what this sort of sounds like, a due process argument, if he felt that his due process rights were being affected this way, he could have come into court and set a minimum price based on the market analysis. If you look at what Judge Decision in the transcripts and what Judge Decisions was talking about, He was talking about that he had no market analysis. He just set the price. And when he had control of the house and control of listing it, the price was well above market value. But what's not here and what's not in the record is the fact that Mr. Zeller did not cooperate with Attorney O'Sullivan. Attorney O'Sullivan had to come back to court with an application to have exclusive, essentially being in charge of the house and making Mr. Zeller leave because he wasn't preparing it or staging it for people to come in and see it. And the second, I think if you'll remember from my brief, the second thing that he did is he endangered the physical plant of the house by putting smoldering debris near the wood siding of the home. So as a practical matter, Mr. Zeller was not cooperating with the initial broker who didn't renew her listing because she couldn't have Mr. Zeller, as counsel has noted, he has an unusual personality. I'm not sure what that means other than, in this context, the man is the very poster child for refractory and contumacious litigation conduct. He didn't want to do it, and he wasn't going to do it. And there wasn't anybody that could make him do it. And that's where it all came from. And I think at some point, the judge simply said, after 13 contempt applications, enough is enough. My client was deserving of repose in this case. He said he had to sell the house in order to pay her. He was supposed to pay her by a date certain and didn't, defended it by saying he needed to sell the house, and then refused to sell the house. At the bottom of this, all the contempt judgments should be read together. Mr. Zeller was in contempt, his contempt continued, and the mechanism by which the contempt was to be purged did not deprive him of due process rights. He had full access to the courts. He could have complained about any aspect of the process, and he didn't. That was his choice. He was not prevented in any way. And the reality is, and perhaps this is outside the record, but the house had septic problems, electric problems. It had been, if you walked into the front door, the smell would punch you in the face. He didn't use the heat or the AC appropriately. There was mold throughout the house. So as a practical matter, when they talk about market price and how it was sold below market price, honestly, they were lucky to get the $400K that they got. And they got that from somebody who had money and put money into the house to the tune of about $250,000 to bring it back. Because it was at one time owned by the owner of KB Toys. I'm not sure that you guys know what KB Toys is. But KB Toys at one time was a fairly successful business enterprise. And that individual lived in the house before the Zellers. The Zellers bought it from him. And at the time, it was in great shape. And it was completely depredated at the time of the sale. So as a practical matter, there was no market analysis done. When Mr. Zeller was initially listing the house, as you'll see from the court's decision, he wanted to list it above the recommended price by the broker, considerably above. And he had no basis for that, other than from his basis was he needed to get a certain amount of money out of the house over and above what he needed to pay my client, which is not the basis on which to list that house. He was not in a position at that point, in that case, to maximize the value of any asset. He had a date certain by which he had to pay my client, and he needed to liquidate assets to be able to do it on his own admission. He had to liquidate those assets. That was his call. He could have borrowed the money from his family, who was wealthy. He could have paid some of the cash that he still had in his possession and liquidated his retirement account to pay her in full, and he didn't. He had the ability and the wherewithal to avoid all of this. He just didn't, because he didn't want Jill to get the money. The other things, I think I've addressed everything except the mootness issue, which Your Honor rightly brought forward. Even if you agree with counsel, which I suggest respectfully you shouldn't, but even if you do, the horse is out of the barn and has galloped across the field into the sunset. There's nothing we can do here. It was a bona fide purchaser for value in an arm's length transaction. And all that happened was that orders of this court that were not appealed have now been satisfied. So even if you find that the judge perhaps did not include some wording in his Rule 70 order that he might otherwise have included or more properly included, I'm not sure there's any damage, and certainly not any compensable damage, because we can't unwind the sale, and we can't unwind the payment to my client because it was paid pursuant to a court order that Mr. Zeller was in contempt of. Not the Rule 70 piece, well, but two contempt orders before that. So as a practical matter, Counsel O'Sullivan was paid for her efforts. There was no application brought in court suggesting that Counsel O'Sullivan overstepped, did something she shouldn't have done, or in some respects charged too much. None of it. She was paid, Jill was paid, and Mr. Zeller received the balance of the money. I'm not sure that there's anything for this court to do other than to say, well, if you find this, other than to say, well, we would have liked to see something else in the Rule 70 order, but there's no, it's the functional equivalent of having one of those liability cases where there's liability, but the damages are $1. There are no damages here. His obligations were satisfied. And with that, I will stand on the balance of my brief.
Thank you. Thank you both. We'll take it under advisement. With that, I'd like to thank my panel, the court officers, the clerk's office, our law clerks, and our excellent timekeeper. And with that, we'll stand in recess.